we first have a presentation by Silvia Rainone, who is an affiliated researcher at the Catholic University of Leuven. Apparently you have two of them, and also an affiliated researcher at the European Trade Union Institute, and the subject is on the notion of appropriateness, what we call sometimes opportunité in French, and legality tests. You have the floor.
Thank you very much. So first of all, thank you very much for having me here. It's been very interesting so far. And with my presentation, I hope to intervene and maybe expand some of the points that have already been presented so far, especially touched upon by Jean-Paul Tricard in his presentation. Indeed, I would like to focus, first of all, on the reason why the Commission rejected, according to his communication of 5 March 2018, the framework agreement stipulated on information and consultation of public sector. So the reason that the Commission based its refusal are indeed based on appropriateness, and indeed are that the central government administration are competence, especially competence of the member state, and then if there is this framework agreement becomes a directive, then there may be a diversity.
There is a problem with the sound in the hall. The people cannot hear it. Oops. Apparently, the people at distance.
Yeah.
Okay. Now it's good. It's good. I have a confirmation that now it's okay.
Okay, we'll start again.
Thank you for saying.
So I was thanking the opportunity to be here, first of all, and I was also mentioning that my brief contribution will touch upon some of the points already mentioned earlier, and it will be about the discretion and the type of assessment that the Commission can perform in relation to framework agreements stipulated by social partners. Because if we go back to the reason why the Commission refuses to transmit the framework agreement to the Council, we find out that those reasons are based on opportunity, are not based on legal fact, but are based on appropriativeness assessment. And those reasons indeed are that information and consultation are already present in many of member state public administration, that if this framework agreement become legislation, we will have a differentiated type of protection across the member state, as well as that the public administration are competence of the member state, and the European Union should rather refrain from intervening in that sector. So what we have is indeed an appropriateness assessment. This fact is also stressed by the General Court ruling, where indeed the General Court stressed that the Commission found that this framework agreement was not necessary or appropriate. It never mentioned the fact that it was not legitimate or valid. Again, in paragraph 79 of the ruling, the Commission says that this assessment, the assessment of the Commission, was based on reason of political, economical, and social consideration. Therefore, the assessment was based on this very broad criteria. So we are going to now check if the Commission, let me see if this, okay. If the Commission could actually perform such a broad assessment, such appropriateness assessment of the framework agreement. And in order to do so, we need to go a bit back to the basis. And indeed, we know that social dialogue, as Jean-Paul Tricard previously said, can lead to two types of framework agreement. One we can refer to as autonomous framework agreement, and are those that find a legal basis in Article 155, paragraph 1, and is when the social partner decide autonomously about the opportunity to negotiate and conclude an agreement. Then we have another type of framework agreement concluded by social partners, and these are the framework agreements that they are negotiated during a formal consultation. And this can be either the first phase of the consultation performed by the Commission, either the second phase of the consultation.
Donc on me signale que l'audio n'est pas top. Je ne sais pas si on peut faire quelque chose.
Je dois parler plus proche? Okay, je bouge trop. Désolé. Okay, so we have these two different agreements. Autonomous agreement negotiated according to Article 155, paragraph 1, and instead we have agreements that are negotiated during the formal consultation track, and they found a legal basis in Article 154, paragraph 4. According to the treaty, the legal validity of those agreements is exactly the same. Both agreements can become legislation and can be implemented. However, what changes is the type of assessment that the Commission can perform in relation to those agreements. Indeed, according to Commission communication that were already mentioned earlier by Jean-Paul Tricard, and especially I want to refer to the Commission communication from 1998, the Commission can only perform appropriateness check in relation to those which are the autonomous framework agreement. In relation to the other framework agreement, the Commission can only perform a legality check. It can check whether the social partners had indeed a correct mandate and they were representative. And the reason why there is this difference is that the Commission presumably already performed a test about the appropriateness of such measure while it was deciding to start and launch a consultation about such measure. So we have these two different specificalities about the process and the power of the Commission in relation to the framework agreement. Why is this important? Well, this is important because the agreement, the framework agreement that led to the EPSU case and that was object of the refusal of the Commission was an agreement negotiated according to the Article 154, paragraph 4. It was a framework agreement negotiated during the formal consultation phase. Therefore, such agreement should have not been object to an appropriateness test. And this, I believe, this point really, jeopardized the argument of the General Court. It really contested the power of the Commission in relation to such case, such agreement. Well, it should also be said that in the General Court ruling itself, the Court contested the validity and the relevance of those Commission communication. However, it's important to notice that the Court of Justice itself, in another case, which is the UAFMI case, based its own reasoning on those exact communication. So that's also a contradiction in itself performed by the Court. Even if we don't want to take this quite strong argument in consideration, and we also accept that the General Court admit that such appropriateness test could have also been performed in relation to this specific framework agreement, we should also consider what is exactly appropriateness test. Is this discretion? Does the Commission can base this test on very broad criteria? Well, I will argue that that's not the case. And indeed, I mean, as I will repeat again a paragraph of the judgment of the General Court. In paragraph 79, the General Court says that the Commission could base its appropriateness test on political, social, and economic consideration. Well, such an assessment based on such broad, vague, indeterminate criteria necessarily lead to solution and to decision which are not predictable and indeterminate, are multiple, and the discretion of the Commission itself cannot be easily reviewed because the criteria themselves are too broad and vague. This argument can also be supported by a review of the Court of Justice cases, and indeed came to my mind that the Ajet Iraklis case that was for a period quite famous among labor lawyers for, well, not the best reason, but it could be used now to stress that in that case, the Court of Justice say that when a public authority refuses to grant authorization with respect to an outcome of private actors, such refusal cannot be based on a discretion based on broad criteria. So such refusal cannot be based on an appropriateness assessment based on broad general economic and political consideration. Therefore, also this appropriateness test can be considered invalid. So here there are two arguments to say that the power that the Commission exercised in relation to the framework agreement should really much considered by the Court of Justice as not valid. And well, this is the conclusion of the consideration I wanted to give you. So thank you for this. Thanks.
Thank you for these very appropriate observations. And then we have a little panel, you could say, which will deal with a horizontal subsidiarity, a principle which pleases me because it's already there in the papal encyclical Quadragesimo Anno. And the three colleagues, they are presenting, will be in subsequent order Melanie Schmidt from the Strasbourg University, and also Antonio Garcia Munoz, a researcher at the University of Luxembourg, and my friend also Massimiliano Delfino from the important university Federico II of Napoli. So I will first, I understand that there has been some consultation between the authors or the speakers, which is already an application of subsidiarity, to to come to a complementary approach. And we will start with Melanie Schmidt. I hope she's there.
Yes, I'm with you.
Yes.
Can you? Okay, you hear me. Okay. So, can you just confirm that you can hear me?
Yes, the sound is excellent.
Great, thank you, Philippe. Dear organizers, dear Sylvia, dear Philippe, thank you very much for giving me the opportunity to take part to this very interesting and I'm sure this very important workshop. So I will try to share my screen, hoping that...
Yes, something's happening, yes.
Okay, great. So, here we are. So, the reason why the principle of subsidiarity needs no less than 3 speakers stems from 2 paragraphs of the EPSU judgment, in which, as you can see, the court holds that, contrary to what applicants suggest, the principle of horizontal subsidiarity does not exist in EU law. Following what
can you move the presentation? Can you move the slides, Melanie?
So I did it on my screen, but
okay.
So I will try.
Yeah, okay.
So sorry for this. So this topic is one of the necessary ones of this workshop, as I said just before. Following what just Mr. Tricker has said, I think that the court totally misses what subsidiary is in the context of social policy. So the purpose of my presentation is to demonstrate that social or horizontal subsidiarity do have legal consistency in EU law, in the sense that it translates into legal mechanisms and principles the very old idea of subsidiarity, which is anchored in European societies and in what we can call the European thought since antiquity. For this reason, I prefer using the term social subsidiarity instead of horizontal subsidiarity, which in my mind correspond to a narrow and too formal view, while social subsidiarity puts emphasis on the substantive meaning of the idea as it was originally designed. I will develop this idea of subsidiarity in the first part of my presentation. And because I'm French, I always have two parts in all my presentations. And in the second part, I will further elaborate what I call the system of social subsidiarity in the EU legal system and its implications for social partners' collective autonomy. So, let me first introduce the idea of subsidiarity. My reflection I elaborated in my PhD thesis at that time lies on the very essence of the philosophical, political, and social idea of subsidiarity. Evidence of this idea can be traced back to the thought of Aristotle, St. Thomas Aquinas, and later, at the turn of the 17th century, to the philosophy of Althusius, who was the first who described what we can call a subsidiary society. The work of Althusius, together with other sources of inspiration, like the social doctrine of the Catholic Church and the personalist movement later on, contributed to the building of modern theories of the subsidiary state. The interesting point here is that subsidiarity emerged in a context of a society composed of multiple social groups, and that this principle is still considered as the fundamental principle governing our postmodern states and societies. And we can find this very interesting idea in the work of Jacques Chevalier. In substance, the function of subsidiarity as a principle of governance is to designate the actor who will be given decision-making powers. But it is not a neutral principle. It lies indeed on the so-called principle of proximity, which reflects the conviction that social groups, and after them local authorities, are best placed compared to distant public authorities to regulate relationships and activities of people they represent. So the best placed actor, both geographically and functionally, have priority in the decision and law-making processes. The very idea of subsidiarity thus means that actions of central public authorities are subsidiary. They are supposed to be taken only when actions of social groups or local authorities have proven insufficient. In the relationships between social partner and public institution, generally speaking, the idea of subsidiarity means that social dialogue have precedence over public initiatives. Subsidiarity both founds and guarantees collective autonomy of social partners, even when public actions turn to be necessary. Moreover, in these cases, the very aim of public actions is to restore, to help, or to complement collective autonomy, so that respect for social partners' collective autonomy lies at the heart of the idea of subsidiarity. What stems from this brief overview is that subsidiarity comprises two dimensions, a vertical one and a horizontal dimension. Yeah. The EU legal system reflects this duality by including vertical subsidiarity in Article 5 TEU, governing the exercise of shared competences between the EU and member states, and the principle of social subsidiarity in the context of social policy. It is therefore correct to assert that social subsidiarity cannot be based on Article 5 TEU, like the court held in the EPSU judgment, However, it is not correct to deduce that social subsidiarity does not exist in EU law. On the contrary, we will see now in the second part of my presentation that the system of social subsidiarity stemming from EU primary law reflects totally this philosophical meaning of subsidiarity. So in the context of EU social policy, the horizontal or social dimension of the principle was explicitly recognized by the Commission itself as the foundation and of the interpretation and the application of Article 154 and 155 TFEU. These articles, which are at the heart of the EPSU case, translate into legal mechanisms and provisions the very idea of subsidiarity and its two phases or stages. That means that, on the one hand, collective autonomy of social partners at EU level can develop freely, is protected from public authorities' interference, and have priority over EU actions. Collective autonomy of EU social partners is then very far from dealing only with the choice made by social partners of the way their European agreement shall be implemented. The court already recognized in its EPSU judgment that certain elements of the processes stemming from Article 154 and 155 must be left to social partners' autonomy. From the decision to open negotiations, the choice of the topics of negotiations, the recognition of legitimate partners, and the capacity to join the table of negotiation, to the decision to sign or not an agreement, and of course the choice for the implementation process. Furthermore, Article 152 of the TFEU, already mentioned in a previous presentation, can be analyzed as a more formal legal expression of the very idea of subsidiarity and its two elements, again, respect for social partners' autonomy and subsidiary actions for the development of this autonomy. Moreover, respect for social partners' autonomy is much obviously reinforced by the fundamental rights of collective bargaining and freedom of association, both enshrined in the Bill of Rights of the EU in Article 28 and in Article 12 of the same charter, which both remained underestimated by the court. In my view, all these EU primary law provisions form what we can call the system of social subsidiarity. But the system would not be achieved without a last and important element, which lies in the second stage of the social subsidiarity principle, and it implies for EU institutions a duty to act, an obligation to act when necessary, when collective autonomy has failed, partially or totally, in order with the view always to help collective autonomy to be fully deployed. So when a European agreement is signed by social partners, especially after a consultation made by the Commission on the basis of Article 154, the Commission must act in order to ensure the implementation of the result of collective autonomy, which is a European agreement. And the legality check from the Commission must not be seen as a way to undermine collective autonomy, but as a way to help social dialogue to be effective, to gain its effectiveness through an EU directive. This is a question of respect for collective autonomy, which again lies at the heart of the principle of social subsidiarity. This is the end of my very brief presentation. Thank you very much for your attention.
Thank you very much, Melanie Schmidt. I think this is also a very good introduction to the subject from which the others will profit. I give the floor to Antonio Garcia Munoz, who risked his life coming all the way from Luxembourg to Brussels.
Apparently, I was the only one that dared to come to Brussels, but I had a reward by, I could enjoy the hospitality by Philippe Dausemont, so I want to say thank you very much to him and also to Sylvia for organizing this amicus curiae that I think is an excellent idea. We are 3 speakers on the idea of horizontal subsidiarity, so we decided to try to not to overlap as much as possible. So Melanie Schmidt has described the principle of social subsidiarity, as she prefers to call it, and I will try to connect this idea as it is in the case, in the EPSU case, with other ideas that we have already discussed, just with the intention to illustrate that even if the court says simply there is no such a thing as horizontal subsidiarity, this is a concept that is central in the system of social dialogue in Europe and should have been discussed more seriously in the case. Because as Melanie Schmidt has already said, social subsidiarity is central for collective autonomy, and I would say that coming from a system like the Spanish one, the idea of autonomy of the social partners means that there is confidence in the trade unions and employers associations in the sense that they are capable to regulate autonomously working conditions. And I think this is very central in the idea, in the original idea of social subsidiarity. But here I will make a connection with what Jean-Paul Ricard already said. EPSU case does not come or should not come as a surprise. Maybe it's a surprise in many ways because of the level of the argumentation, but it follows a certain path that was already there. So the devaluation of the idea of autonomy of the social partners is previous to the EPSU case. And here we could talk about the what does imply the assessment and the whole refit exercise for an agreement that has been negotiated by the social partners, or what does, or even the refusal of previous agreements like the famous hairdressers agreement, that even if it's an agreement that was autonomous in the sense that Sylvia has explained it, nevertheless was negotiated for a long time, then it was welcomed at the first moment, then it was delayed forever, then it was never adopted, then the social partners that negotiated it were told, well, we won't transpose this agreement. So this evaluation of the work of the social partners, of the idea that they can autonomously develop a regulation was there before EPSU. I think this lack of confidence in the capacity of the social partners to auto-regulate working issues connects again with something that we have already discussed, and is the Commission as the only interpret of what is general interest in the European Union. And so what is behind this? I think behind this there is a model of democracy at the end. So I connect here with other topic. Horizontal or social subsidiarity can be related to a model of democracy that is pluralistic model of democracy in complex societies where decisions are not just the outcome of an optimal solution or a general interest that is there and we just have to discover it, but it's also the result of different interests that are even opposite. And there can be conflict in the definition of the interest, and the outcome is the result of this conflict. This model of pluralistic democracy is absent in the EPSU case, I think, because the references that the case makes to a very limited idea of parliamentary democracy that Philippe d'Orsemont has said Jacobin model of democracy. I think Antonio Lofaro goes a step further and talks about 19th century Victorian style parliamentary democracy. All this is there behind the concept of these models are implicit in the social subsidiarity or the absence of social subsidiarity. It is surprising how the court just denies the existence of social subsidiarity and denies any legal value to the communications of the Commission, and does not even engage in a kind of to discuss the interpretative value of these communications, and does not provide arguments a little bit more developed or sophisticated to deny the existence of social subsidiarity. This led me to look if the Commission, because the Commission says in the case there is only subsidiarity, and it's not, there is nothing like social subsidiarity, only subsidiarity. So I wanted to understand how the court understands subsidiarity in general. And well, there is a lot written on this point, but there are some cases where the court seems to understand this just as a kind of technical rule to decide who is competent. And the criteria would be measured in terms of efficacy. So we have a goal, and we want to understand which is the more efficient level to regulate something, and then we decide if the most efficient level is the national level, then we don't intervene. Otherwise, we intervene at European level. But of course, this translated to social dialogue context would mean that we don't give any value per se to the autonomy of certain groups and their participation in the making of the regulation at the European level. So this idea of subsidiarity in general makes very difficult to accept an idea of social subsidiarity. But an idea of social subsidiarity goes much beyond this idea of the efficient level of regulation, because as Melanie Smith has already said, if collective autonomy is at the core of social subsidiarity, it is because collective autonomy per se has a value, at least in many constitutional traditions in Europe, and we thought also because the treaty makes references to the autonomy of the social partners that it also had a value per se in the European Union context. I think I have said everything I wanted, and I will stop here and give the floor to Massimo, because he will continue with the same topic. Thank you very much.
Okay, so Massimiliano, you have the floor from Napoli.
Yes, thank you, Philip. Thank you, Silvia and Philip, for your distance hospitality and for your invitation. Before I start my presentation, I would like to say something about the topic of horizontal subsidiarity in general. The first thing is that everyone has already said that subsidiarity has a twofold dimension, has a double dimension, horizontal and vertical subsidiarity. But in my opinion, these two dimensions are not fighting one with each other, so are not in competition. There is not a fight between horizontal and vertical subsidiarity, but they must be interpreted together, they must be coordinated one with each other. The second thing is that we have to remember, that when the social partners ask the Commission to implement a collective agreement by a Council decision, they are making union law on a par with Council and European Parliament. So I think we have to consider the collective agreement as part of the system of the sources of union law. This is very important, in my opinion. Then someone has already told us that we have to distinguish between induced negotiation and voluntary negotiation, so autonomous negotiation and induced negotiation. And it is a very important point, in my opinion. If all this is true, all this can be considered as true, as regard to the principle of subsidiarity, in my opinion, three cases must be distinguished. One concerning autonomous negotiation, and the other two regarding the induced negotiation. In the event of a voluntary negotiation, concluding with a collective agreement that shall be implemented, neither the Commission nor any other union institution has been involved in applying the principle of vertical subsidiarity provided for in Article 5.3 of the Treaty on the European Union. And this is the first case. On the contrary, in the event of an induced negotiation, the negotiation inside the information and consultation process, a distinction must be made depending on when social partners decide to inform the Commission of the intention to start the procedure referred to in Article 155. Indeed, such a decision can be taken immediately after the consultation of the social partner by the Commission. I'm referring to Article 154.2, as happened in the EPSU case. And this is the second hypothesis. Or subsequently, when the Commission considers union action admissible. And this is Article 154.3, and this is the third hypothesis. The case of the voluntary negotiation is like that of the negotiation induced after the first consultation of the Commission. Instead, if the decision of the social partners is communicated at the time of the second consultation, the situation, in my opinion, is different. In the first two cases, a collective agreement is concluded where the Commission is only actually involved in the phase following the stipulation, or had a very marginal role. Therefore, the first act that the Commission carries out is to apply the principle of subsidiarity, and in doing so, it cannot be replaced by the social partners, because Protocol 2, annexed to the Treaty on European Union, provides that the respect of the principle of subsidiarity shall be ensured by each institution of the Union, an expression that cannot be referred to the European social partners. Furthermore, according to Article 17.2 of the Treaty on the European Union, Union legislative acts may only be adopted on the basis of a Commission on the basis of a Commission proposal, except where the treaties provide otherwise. An exception that, in my opinion, that does not seem to occur in the case of social dialogue, since Article 155.2 provides that European collective agreements can be implemented by a Council decision, but precisely on a proposal from the Commission. Therefore, in the first and second cases, the European institution, the Commission, can motivate its possible refusal in any way, because that is a political act of exercising the principle of vertical subsidiarity. In the third hypothesis, in the third case, the issue changes. The Commission intervenes at the time of the second consultation, and therefore has carried out an assessment of the appropriateness of the regulative intervention, although not yet on its contents. In this case, the European institution deemed it advisable to carry out a regulatory intervention by the Union, entrusting the social partner, upon their request, to define the content of this intervention through the conclusion of a collective agreement. If the social partners, after concluding the collective agreement, ask for its implementation by a directive, the Commission will have already expressed an appropriateness assessment and will only have the possibility of making an appreciation of the contents of this intervention, i.e. of the clauses of such an agreement. In this case, however, it will be necessary to provide a rationale for the possible refusal to submit a directive with legal and non-political reasons. When I say legal reason, I mean the legality check and the representativeness check. In my opinion, the most controversial part of the judgment are the explanations related to the general interest issue. On this topic, I totally agree with all the other participants to the debate. But in this case, on this topic, I would like to stress another important thing, which is a cornerstone of the EPSU judgment. And this cornerstone is the role of the Council in the implementation of the directive concerning the collective agreement. I think neither the Commission nor the Union applicants in the EPSU case contested that the Council has a very wide discretion in this case. Since the Parliament shall simply be informed in this case, the Council is the only EU institution that exercises the legislative power of the Union and cannot be bound by the determination of the European social partners. The discretion of the Council is wide, and any vote against the approval of the directive, being a wholly political legislative act, does not require any motivation. So my idea, I don't want to pass as an amicus commissionis, a friend of the Commission, more than as an amicus curiae. But I think, in my opinion, is that in the EPSU case, the collective agreement was the result of an induced implement negotiation, which started at the time of the first constitution of the social partners. And in such a case, or in the similar case of a voluntary collective agreement, the consequence deriving from the combined reading of both the treaty, and that is another point, that the last point that I want to stress, there is no competition between the Treaty on the Functioning of the European Union and the Treaty on the European Union. So in my opinion, we have to interpret those treaties in coordination and not in competition. So the consequence deriving from the combination, the combined reading of the articles of the treaties is that there is no need to provide a motivation for the refusal, because the Commission has not yet applied the principle of subsidiarity by means of a political act. The same happens, in my opinion, in the ordinary legislative procedure of the European Union, when the Commission is not required to state reasons for not submitting a proposal for a directive on a specific subject matter. Just like the national government in all our legal systems is not obliged to give a motivation for the non-submission of a bill. Thank you very much for your attention.
Thank you, Massimiliano. I don't know whether you are an amicus curiae or an amicus commissionis, but you are an amicus tout court of this community. And you already raised a number of issues, I think, which even might be taken up later. And I appreciate your way to overcome the divide between horizontality and verticality. I think Hegel would have been proud of you. And then we have, of course, from the Netherlands also a contribution of Beryl Terhaar, who is affiliated at two universities, Leiden University and Warsaw University, and she brings into the debate, of course, an important text instrument, the European Pillar on Social Rights, also known as Socle des droits sociaux in French, although that is another piece of architecture, I think, than a pillar. Beryl, you have the floor. Yes, I see you.
Thank you, Philippe. Yeah, thanks. Thanks also for organizing this. It's a great initiative. Yeah, I said I would be talking about the European Pillar of Social Rights. And when I indicated this, I was inspired by a publication of EPSU called the European Pillar of Broken Promises, Time for a Social Europe. And in relation to the case, this made me think a lot about like what are actually the expectations, and it has been addressed already in many different ways. I think in almost all the talks. So I feel like I have a little bit of a disadvantage of being much in the end, as it feels that I'm gonna repeat a lot of things that have already been said. But I take a slightly different approach to it. So I think it's still, or I hope it will still be of value. When looking into the European Pillar of Social Rights, I also came to the conclusion for myself that it's impossible to only value this based on what is in the European Pillar of Social Rights. So what I did instead is I kind of followed three sort of narratives for myself to find out what are these expectations based on, and then how can we situate the European Pillar of Social Rights in this, but also what does this mean in the end for, well, how did it come that we have this case now and how to think about this case. So it's not going to be very legal as some of the other presentations have been, but again, I hope it is of any value. The narratives that I developed is first a more historical perspective. and then especially focusing on the Val Duchesse meetings and the beginning of the whole social dialogue. What was kind of set up there, what kind of expectations were developed there, and how did it evolve from there. The second narrative follows the development of social dialogue in the EU's, let's say, social policy documents, something like the white paper on European social policy, but definitely also then this EU pillar on social rights. And the third narrative, I'm looking at what we are doing in the doctrine, and then especially in the handbooks on EU law, on EU labor law especially. General books on EU law quite rarely address social dialogue. As has been stressed by some of the previous speakers, general EU experts do not really seem to grasp this idea of social dialogue and tend to overlook it or not see it as another form of legislation, which is very differently in EU labor law. By following these narratives, well, I think it's interesting because it gives us an idea of what in social sciences and international law sometimes is indicated as this epistemic community. We together develop some kind of a vocabulary, sort of understanding of how we together perceive something, see something, and understand something. So I hope to get from this some indications on expectations, and apparently something has gone wrong that we got into this case and let's say big fight in front of the court. Where is that coming from? And I hope that giving some insights on this might be helpful for the court as well to, well, give a different evaluation than it has done, than the general court has done. I'm not going to take you through all the narratives. I only have 10 minutes, so I'm going to share with you some of my reflections on what I get from the three narratives. And from the first narrative, the impression that I get is, well, it is clear, and I think this is known to many of us, that Delors and his team took a lot of efforts to get social dialogue over the deadlocks that it had gotten into up till the 1984, and also to get both sides of industry on the same page. So I don't need to elaborate a lot on this, I guess. And especially in this beginning, with the first summits and meetings, the Commission has always been quite strongly involved. And even though you could say still the autonomy of social partners was respected, somehow the Commission was constantly present just to bring social partners and to bring the whole process forward. And against this background, I think two things are interesting regarding the created expectations. First, with these early efforts by the Commission, they were aimed at making it attractive for social partners to engage in a social dialogue. And this has resulted in maybe sort of an over-positively response to of the Commission to any positive outcome of social partners. So you could say when we're talking about expectations, it had feeded the expectation of social partners that if they reach a positive outcome, like an agreement, the Commission will welcome it and will be willing to take it to the next level, including presenting a proposal for a decision to the Council. So I'm not looking here at legal text as, for example, Massimiliano has done, just looking at the context around it, right? And second, because the Commission had always been actively involved to get social partners together, the Commission was also quite well aware and informed about what was being negotiated. So then whenever something was reached and presented to the Commission, it was not a surprise to the Commission. The Commission knew the content. So here I would see there has never been, in this time frame, in this setting, there has never been a feeling or a need to check any of the appropriateness because the Commission had already grown into it. So from the second narrative, I get quite a strong vision that EU social dimension just cannot be developed without the involvement of social partners. So very strong recognition of its role. And every new policy document stresses this role of social partners, of social dialogue, and the need for a better and enforced social dialogue. And it seems that the Commission is always supporting it, with the exception of the Barroso Commission. And that has been elaborated on already before the break also. The Juncker Commission did give the impression that it gave a new sound with words like new impetus for the role of social partners and social dialogue. And here is where we see the European Pillar of Social Rights come in also, which includes key principle 8, where it stresses the role of social dialogue. But here I get a little bit more critical. So far it was always putting social dialogue at the heart of social policy, the social dimension. And I wonder whether this is really the case with the European Pillar of Social Rights. It is in the pillar, which of course is important, but we're talking here about social dialogue, about collective labor law. We're talking here about something that is facilitating for all the other rights that of the European Pillar of Social Rights. And for me, it feels that taking social dialogue and the role of social partners as 1 out of 20 principles is sort of not acknowledging the full and real meaning of social dialogue and social partners. And I see and feel here a different approach than it was when Jacques Delors was developing the internal market and really trying to push for social dialogue because it needed it. And it has been stressed by a few others already as well. Maybe this sense of that it needed it has become a little bit less. So I think that the promise in the European Pillar of Social Right is less big as might have been perceived in general, or at least in the whole constellation together with all the other principles. And here I keep also in mind a bit more the ILO's approach in its decent work agenda, where it is very clear that the collective rights, they are also facilitating rights, so they're not only fundamental right, but also fundamental right because they enable all the other rights. And so it has sort of a double role position in the ILO's decent work agenda. And it would have been really nice, and if you really recognize this, then you would have want to find something like this in the European Social Pillar, and it's not there. Moving to the third narrative, that's quite a simple one. It's actually talking about us. And what I've noticed when I look at least the handbooks on European labour law, we all seem to perceive it as social dialogue, social partners as co-legislators next to the Commission, which has been stressed especially also in the very nice 3 presentations preceding on horizontal subsidiarity. And we seem to be all kind of on the same page, and we reflect very much the early 1990s when Delors succeeded in getting social dialogue running. So then I reflect a little bit on the narratives in combination with each other, and here I think I see something interesting between narratives 1 and 2 that I thought would be nice to share with you. What I get is some sort of an impression that seem to have a counterproductive effect. It's rather subtle, and I find it really difficult to pinpoint what it is exactly, but I'm going to try. So what I see is, on the one hand, the dynamic in the Commission, and on the other side, in social partners. The dynamic on the side of the Commission relates to the shift from hard law to soft law. It has been stressed a few times already in the mid-1990s, and then also with this Barroso Commission, slimming down initiatives on social policy, the introduction of the Lisbon strategy with the open method of coordination, its continuation in Strategy Europe 2020. Well, we all know already that the role of social partners in these initiatives is not very strong, slowly getting better, but still it's not very strong. But what we seem to maybe not so often tend to see is that the role of the Commission compared to legislative acts is also not very strong, especially not in this open method of coordination that got a strong foothold in the field of social policy. The institutions, the EU institutions that are driving the open method of coordination are the European Council, the Council, and the member states themselves. And for as far as the Commission is involved, it's more in a facilitating role in feeding the European Council and Council with information, with a review on the country reports that member states have to submit. But all in all, you could say that the role of the Commission itself in social policy field, when it comes also to legislation, it is not that much anymore, if I can express it in that way. The other impression that I get if I put narratives 1 and 2 together on the side of social partners is that I can see, or the impression that I get, is that they have grown much more in their role and seem to be more and more comfortable in various social dialogue fora at EU level. Well, social partners have been fighting for getting more involvement in the Lisbon strategy, etc. So you could say that the influence of social partners on EU social policy in the soft law procedures has been growing. Still, and a lot needs to be done, and still not what it should be, but it is growing, and social partners are growing up. And you can also see it in sectoral level negotiations. There's much more dynamics going on there without necessarily having the Commission involved there as well. So where I see is that we have two dynamics where the Commission on the one hand is struggling to find its own role in social policy, where social policies and social partners seem to be consolidating their role more and more independently from the Commission, which I think has resulted into some sort of a new relationship between the Commission and social partners. And I have some sort of a feeling, but again, I find it very hard to pinpoint it, that this case that we have now and already in the hairdressers, with the hairdressers agreement that Antonio referred to, that there is sort of a fight between the Commission and social partners in who is the most important here in the field of social policy. And so that's not really helping each other out. I'm going to conclude off because we are already running out in time. I wanted to elaborate a little bit more about the wider EU perspective and how Commission is critically reviewing it. I think that's one of the symptoms of trying to find a new balance between the two, because of how it might have grown, or how I see that it might have grown. But Sylvia has pinpointed quite a good points on that. And I also saw this comparison with the Heracles case that she indicated. So what you get from all the three narratives, another thing that I wanted to stress, but also has been mentioned already, social partners are not just one among many interest groups, right? They have a specific role, especially when it comes to social policy. That is not debated. They are at the heart of social policy, although I think with the European Social Pillar that could have been stronger. So what I think and get from these narratives is that there has something grown differently in the relationship between social partners and the Commission, and it's being fought out now in court. I wonder whether that's the right place. Maybe we need just a new Val du Chasse process or something to have them look each other in the eye and really recalibrate how are we going to make this social dimension in the EU. Thank you.
Okay, thank you. Thank you for this broad perspective and the three narratives and the interaction between the three narratives.